What happens if I don't list an executor or a personal representative to my will? What happens? We had a do-it-yourself will that we were taking through the probate process. Wills go through probate, they control probate. And it was just something someone did on their own, and they named their spouse as the executor. But their spouse had passed, they never did it professionally, they never had it redone, and now we don't have an executor. We don't have someone to take us through the process. Who is that? My name is Philip Bruce. I'm an estate planning attorney here in Minnesota, and if we don't have it listed, your will or your revocable trust can name who is in charge of the estate, who has the ability to sell the house, who has the ability to access the bank accounts, who can pay the bills. We need that authority. If you have a revocable trust plan, we can create that authority without court. If you have a will document, then that will document is going to nominate someone to have that authority to the judge, and that gets priority. And that's great. That's why we like to at least have a will, okay? Wills go through probate. As long as you're okay with that, this is the correct tool to nominate your personal representative. Anytime a will is silent on something, then we go back to the default rules. They're called the intestacy statutes, and the default rules are what govern if you don't have a will, or if you do have a will and it's silent on something. We always have the backup rules. And the answer to who becomes your executor or your personal representative is really dependent on you. It depends on your family. If I'm married and my kids are all with my spouse, so it's just the two of us and we have our own children and that's the only children we have. If they're adults, they're next in line. If we have 3 kids, they're all nominated. That's bad. We usually will ask 2 of them to resign and just have one of them be the executor, be the personal representative. If I have a child from a previous marriage, that person is also nominated. So now it starts to get a little messy. If I don't have any kids at all, then it's going to start going to my parents, and if I don't have parents, siblings, and we're going to have to find someone there. It can get very complex, which is why if you're doing a professional will or revocable trust, your attorney is almost certainly going to want at least 1, if not 2 backups. So we would say spouse first if you're married. If you're not married or after spouse, we would then say one of the kids. Typically, you want to choose 1 at a time. This is much better. One of the rare times when it's better to have a dictatorship instead of democracy is this: 1 at a time if you can. Every family's different, but if you can, 1 at a time. And if this person can't do it, then this person. If this person can't do it, then this person. We usually want at least 1, if not 2 backups, hopefully more. So that's what happens. There's a way to prevent it. You just got to have your backups in place. But if it's silent, we go back to those statutes and we figure out what the legislature has picked for us. My name is Philip Bruce. I'm an estate planning attorney. If you have any questions, shoot us an email.